Good morning, everyone, and welcome to our webinar, Human Rights Challenges in Relation to Social Care. I'm Nicola Greaney, and I'm joined this morning by my colleagues Steve Broach and Steph David to present this webinar to you. I'm going to be talking about victim status and Article 2. I'm then going to hand over to Steph, who's going to talk about Article 3. And then finally, Steve is going to talk about Article 8 and also about private providers and their status. As in the usual way, there's the question and answer function that you can use. And what we're going to try and do is have some questions relating to particular topics at the end of each speaker's session. So I'll then start with the first topic, which is that of victims and victim status. So the first thing here, I've mentioned Article 34 of the Convention and also Section 7 of the Human Rights Act, which sets out the requirement that in order to bring a Human Rights Act claim, you must be a victim. And indeed, Section 7, subsection 7 of the ECHR provides that you're only a victim of an unlawful act if you would be a victim for the purpose of Article 34 of the Convention, if proceedings were brought before the European Court of Human Rights. So that's why the case law from the European Court is obviously of particular relevance. The European Court has said on numerous occasions that the concept of a victim is an autonomous one, and it's not interpreted by reference to domestic rules on standing or capacity to bring proceedings. One document which I've mentioned in the second bullet point there, which is very useful when you're looking at particular issues that you have, whether you're bringing or defending a claim about victims, is the Practical Guide on Admissibility Criteria, published by the European Court. And there's a new version of it published last August, actually, so make sure you're looking at the correct one. Lots of the cases that I'll be referring to are mentioned in that document. As I've said on the slide, there's the concept of direct victims and also indirect victims, but as I'll go on to say, there's certainly some overlap, at least in terms of Article 2 and claims being brought by family members, because they've been described in the case law both as that being an example of direct victims and indirect victims. But the test for a direct victim is that the individual is directly affected by the alleged violation, as I've set out there. And the European Court has said that it can include a class of people who might be affected by a particular measure. So class in Germany was the case about secret surveillance of mail and telephone calls in Germany, and the court held that victims were all those affected users or potential users of post and telecommunication systems in Germany. Similarly, in the Campbell and Cousins case, children attending a school where there was a policy of corporal punishment, all those children were victims, even if they hadn't yet been subject to corporal punishment, because they were sufficiently at risk to give them the status of direct victims. As I said, in relation to Article 2, family members have been recognised as direct victims of Article 2 breaches. We know that from the Supreme Court decision in Rabone and Pennine Care NHS Foundation Trust. You'll recall this is the case which was a very important decision in terms of the operational obligation in respect of healthcare providers. And it was the case where the Supreme Court decided, in fact, before the European Court had made a similar decision, that informal psychiatric patients were owed the operational obligation under Article 2. I'll go on to talk in a moment more about the operational obligation, but I'm sure many of you will be familiar with that case for that reason. But the claim was brought in that case by the parents of an adult child, and their status as victims was challenged in the domestic proceedings. And what was said was that they couldn't claim to be victims of a substantive violation of Article 2. They could only be victims of a procedural violation of Article 2. But the Supreme Court dismissed that and said that it had been accepted by the European Court, that they were parents in this situation, relatives could bring claims as victims, claiming their own right, as it were, in relation to breaches of the substantive obligation under Article 2. And another interesting aspect of that claim was that it was also said that they'd as it were, lost their status as victims in respect of Article 2 because they'd settled a common law claim. And that was discussed by Lord Dyson in that case, who found that they had not, because what they'd actually settled was a damages claim for funeral expenses on behalf of their child, and also a claim for pain, suffering and loss of amenity on part of their adult child prior to her death. They hadn't, because they were parents of an adult child, they weren't in a position to bring a claim for bereavement damages because they don't fall into the category of individuals who can bring such a claim because their child was over 18. So it was found that they had not lost their status to bring a claim for damages for the suffering that they had sustained as family members of the deceased by reason of the violation of Article 2. As I've said, family members can also be recognised as direct victims of Article 3 on account of the suffering that they have arising from serious human rights violations affecting their relatives. And an example of that is the case of Salami and former Yugoslav Republic of Macedonia. That was a case where a relative had been subject to ill treatment and torture by the police, and relatives brought claims both, they said, as direct victims of breaches of Article 3 and indirect victims. And there's useful discussion in that case, which I won't go into in any detail, about the criteria for being found to be a direct victim of Article 3 as a relative. But essentially that was not found to be the case in the case of Salami. There was one of the relatives was recognised as an indirect victim, but not a direct victim. But what the court recognised was there were special factors in relation to Article 3 that had to be made out before you could be a direct victim. And one of the points they made was that the particular relatives hadn't actually witnessed the torture or the ill treatment themselves. And they also said that their relative had disappeared for a period of time, but it wasn't for a very long time. So again, they didn't fall into this special category. So it's interesting really just to note that there are, as it were, control mechanisms that many of us are familiar with from domestic case law in terms of secondary victims, and some similar sorts of criteria are applied by the European Court when looking at direct victims, particularly in the context of Article 3. So moving on to the next slide, I'm now going to discuss indirect victims. So I'll just wait for that to come up. The second slide. I'm just waiting now for Steve because I know he's got control of this. Thank you, Steve. So indirect victims, these are cases where it's been accepted that close family members can bring complaints about, primarily in respect of Article 2, about the death or disappearance of their relatives. In circumstances which are alleged to engage state responsibility under Article 2. And an example of where this was discussed is that a reasonably old case now of Van Col in the United Kingdom, which was somebody who was Mr. Van Col, who was killed by a third party in circumstances where it was said the police ought to have taken steps to have prevented his murder. And the European Court there said that his parents could claim to be victims in their own right in respect of failings under Article 3, but interestingly there described them as indirect victims on the basis that obviously the breach of Article 2 related to the family member. I flagged that up simply because obviously the circumstances are very similar to what I was discussing in Rabot, where that's been cited as an example of family members in those circumstances being direct victims. So I think there's quite an overlap here between the concept of indirect victims and direct victims in relation to Article 2. in my view, there's a helpful discussion in Daniel and St George's NHS Trust, which is a case, again, I suspect a number of you are familiar with. That's the decision of Mrs Justice Lang, where she was considering the status, again, it was a death in custody, and she was looking at whether a former foster mother and also a foster brother could claim to be victims of Article 2 violations. And what she said in that case is that there are effectively two categories of indirect victim that have been recognised by the European Court. The first category is where the deceased next of kin bring a claim representing the estate or the interests of the deceased. So again, as it were, they're bringing a claim on behalf of the estate. But in order to bring such a claim, the European Court's clear you need to have an official status as somebody who's able to bring such a claim on behalf of the deceased. But the second category of indirect victims is where blood relatives are complaining of their own pain and distress or bereavement about the death or other ill treatment leading to death. And she went on to say that a blood tie or marriage is not essential to bring such an indirect victim claim. And she set out a number of criteria that she applied in that case, which include the nature of the legal or family relationship between the claimants and the deceased, the nature of the personal ties between the claimants and the deceased, the extent to which the alleged violations of the convention affected them personally and caused them to suffer, and their involvement in the proceedings arising out of the deceased's death. So as you can see from that list, this is a very fact-sensitive test. On the particular facts, she concluded that it was that she thought that the foster mother just about got over the threshold, as it were, of indirect victim, and so she accepted that she was, but she rejected the claim brought by the foster brother, and in so doing, she said it was not recognised in domestic or European law and was not a formally recognised relationship status that would qualify as a second victim, which would enable the second claimant, because that's what he was in that case, as an indirect victim. She made the point that no case had been cited to her where, for example, friends or work colleagues had been recognised as victims. Another interesting line of case law is that concerning Article 3, and I'll just deal with this very briefly. Article 3 and Article 5, where the European Court has recognised that relatives of can bring complaints under Articles 3 and 5 in respect to the treatment of one of their relatives, as long as the violation is closely related to death or disappearance. So what this appears to be is keeping some quite tight constraints on the categories of people who or the circumstance in which these claims can be brought, and effectively saying that they've got to be related to an Article 2 claim, albeit there are cases where complaints are under Article 3 have gone forward by relatives of victims when it's been found there's been a strong moral interest beyond the mere pecuniary or other compelling reasons. So I think the conclusion from all of this is that all of these cases, you have to look at them quite carefully to see if somebody is going to qualify as a victim, and you have to look at the case law and see whether any of these particular situations or is going, and whether any of these tests are going to be satisfied. But it's fair to say that the guidance is quite opaque and each case is going to turn on its own facts. So I'm moving on now to say something briefly about Article 2. And what I'm focusing on really is the Article 2 with particular reference to care homes or social care settings, because we're obviously not just dealing with care homes. We've got a range of social care settings where Article 2 could potentially be engaged. I'm sure it's an article which you're all familiar with, the protection of the right to life. So I will move on to the next slide, which deals with the various Article 2 duties. What I'm looking at here is not the negative duty to refrain from taking life. I'm not looking at the procedural duty either. I'm looking at the positive duty to protect life in certain circumstances, which has been divided into these two aspects: the general positive obligation and the operational duty. So looking at the next slide, under the general positive obligation in relation to Article 2, as I've said, this is an obligation to have effectively a regulatory framework, a framework of laws which will, to the greatest extent practicable, protect life and provide effective deterrence against threats to life. And it's been found to include, for example, in the context of health or social care, the recruitment of competent staff, the maintenance of professional standards. That if we look at it in practice, moving on to the next slide, there is an important case which is in the healthcare context, this decision of Lopes Fernandes and Portugal, a decision from the Grand Chamber, where the court made it clear that it's only in exceptional situations, certainly in relation to healthcare, that there'll be a finding of a breach of this general positive obligation. And in particular, mere negligence in the provision of healthcare will not give rise to a finding of a breach of a positive obligation. And in so doing, the Grand Chamber was following a line of established case law, which started some time ago with a decision called Powell in the UK. But on the next slide, I've set out these exceptional circumstances when there can be a breach of the positive obligation. And we can see, as I've said here, not mere medical negligence cases. It's in exceptional circumstances that the responsibility of the state can be engaged by acts or omissions of healthcare providers. The first set of circumstances is when a specific patient's life is knowingly put in danger by denial of access to life-saving treatment. And then there's a second set of circumstances, which is all quite complicated and I won't go into in any detail, but you can see there's as it were, an accumulation of factors there that have to be met before there could be a finding of a breach of a positive obligation. So how might this be relevant in relation to the provision of social care? And on the next slide, I've referred to two cases. The first one, Dump and Latvia, and the second one, Maguire, which is a recent decision of the Court of Appeal, and which contains a very important judgment from the Lord Chief Justice, which I'll deal with in a moment. But in the Latvian decision is important. It was a young person with a diagnosis of Down syndrome and epilepsy. He was living in a care home. He had a number of health conditions, particularly skin conditions. He was undernourished. The complaint was brought by his mother, who, as you can see, claimed that there was a failure of staff at the care home, and she was specifically criticising healthcare staff as well as the GP to react to a deterioration in his condition. What happened was he was admitted to hospital and he died of heart failure not long afterwards. But that claim was dismissed by the European Court, who found it was a medical negligence claim. There was no breach of the positive obligation, and they said these were not exceptional circumstances giving rise to a liability under the Lopes decision. And another one is the Maguire case, which, as I said, is a recent decision. It was about the procedural obligation, in the sense that it was in the context of an inquest and whether or not a coroner was required to allow a jury to return an expanded conclusion on the basis that it was an Article 2 inquest. And in so doing, there was detailed consideration by the court of these line of case law and the circumstances in which Article 2 and this substantive obligation under Article 2 can be engaged. Maguire concerned a woman. She was living in a care home. She had learning disabilities and autism. She was subject to a deprivation of liberty safeguards order. She became unwell. An ambulance was called, but a decision was made by care home staff and the ambulance team that they wouldn't, and they consulted with the GP as well, that they wouldn't take her to hospital unless she was compliant. She wasn't compliant, so she didn't end up going to hospital until the morning. And when she got to hospital, she died of a perforated gastric ulcer. Now, both the Divisional Court found that there was no breach of Article 2, or there was no engagement of the positive obligation under Article 2 in either aspect, and the Court of Appeal agreed with that decision. And in terms of this specific aspect, which I was looking at initially, the breach of the general positive obligation, Again, the Court of Appeal said that there was no exceptional circumstances, as per the Lopes decision, that could give rise to the breach. This was not a situation where the life of Mrs. Maguire was knowingly put in danger by a denial of access to life-saving treatment. So then finally, I'll just talk very briefly about the operational duty under Article 2 and when this might be owed. So this is a second aspect of the positive duty contained in Article 2. I've set out in summary the circumstances in which it can arise there. It's a particular circumstances where there's an assumption of responsibility for the individual's welfare by the state, or the victim might be seen as particularly vulnerable, which could trigger the obligation. And then if it's owed, the test is whether there was a real and immediate risk to life. As you can see on the next slide, it derives from a case called Osman in the UK, which was in fact a claim against the police, again, where it was said the police ought to have intervened to protect an individual from criminal acts of a third party. And you'll see what was said there is the authorities must be shown to have known or ought, that they knew or ought to have known at the time of the existence of a real and immediate risk to the life of an identified individual, and that they then failed to take measures within the scope of their powers which judged reasonably might have been expected to avoid that risk. So it's a question, if the duty is owed, the standard is one of reasonableness in the circumstances. So again, looking briefly at when might this operational duty be in play in the context of social care provision. Again, we are looking very much at this recent case of Maguire, I've set out there in summary some of the points that are made in the judgment by the Lord Chief Justice, but the bottom line was that the Court of Appeal agreed with the Divisional Court that the operational duty was not owed to Mrs. Maguire. It was argued that it was owed to her because she was a vulnerable woman in a care home and she was subject to a dole. But the Court of Appeal was clear that this was not a situation which was analogous to psychiatric patients, whether formal or informal, who are in hospital. It was acknowledged that the operational duty can be owed to those in institutional settings, but whether it will depend on the circumstances. And the cases that they focused on were situations where there was knowledge on the part of the authorities of appalling conditions in state institutions. And an analogy was drawn with a case called Z in the United Kingdom, which Steph is going to deal with later, which is an Article 3 case. Again, it was said the operational duty did not apply to the provision of medical treatment in a care home. And it certainly didn't apply to one-off instances of failures in care. So the duty was owed for some purposes only. But nevertheless, it was said that reference was made to this decision of Watson in the United Kingdom, which I've always found quite a curious case, which is where it was recognised by the European Court that the operational duty could be engaged in relation to an elderly patient who's being transferred between two care homes as a result of that person's of an individual's general frailty and resistance to change, which could give rise to a real risk of death. I mean, on the facts of that case, there was no finding of a breach of Article 2, but the European Court recognised, as it were, in principle, that such a case could be made out. Interestingly, this was described by the Lord Chief Justice in Maguire as a defined area of activity. So I think we are left in a situation where, certainly in cases, the cases cited where there's evidence of systemic abuse or neglect over a long period of time, then there could be a responsibility on behalf of the state under Article 2, and the operational duty could be engaged. But in cases where that is not the situation and you've got one-off failings, it will not be engaged. But obviously all of these cases are going to turn on their facts, and the Watson in the United Kingdom is an example of a situation which is certainly on the borderline, but has been acknowledged as potentially raising issues under Article 2. Causation, I'm not going to say very much on that, other than to highlight to you that two approaches have been adopted here. It's not a balance of probabilities test in relation to causation for an Article 2 breach. In Van Col it was said it's a substantial chance or real prospect, but certainly the sergeants and decision suggests you don't need to have a causative link at all. But then you do need to read on, because what's said in that case is that if there's no causative link, then whilst you could have a finding of a violation, it may well mean that there would be no award of damages for such a violation. So that would be how it would come into play. So I've reached the end of my slides. I'm going to hand over to Steph.
Thanks, Nicola. So the focus of my presentation really is going to be looking at the key points that you need to take into account when you're considering a possible Article 3 challenge. No doubt you're familiar with Article 3. The recent case of Ruman and Belgium from the European Court reminds us that the article is framed in absolute terms, and it's irrespective of the circumstances and the victim's behaviour. But the key point to remember in an Article 3 claim is that you meet the minimum threshold. So Steve, we go to the next slide, please. So this has been a concern of the European Court for some time, going back to the Ireland and the UK courts in the late 70s. When it comes to ascertaining whether or not the facts of a particular case surpass that threshold, you need to look at all the circumstances of the case. When it comes to considering ill treatment, it only amounts to torture where it's deliberate and causes very serious and cruel suffering. Treatment can be inhumane if it causes intense physical or mental suffering, and it can be degrading where it arouses in the victim feelings of fear, anguish, and inferiority, capable of humiliating and debasing him or her. And you can see the rest of the quotation there. Just moving on to the next slide, considering how the law's developed. So Salmony in France, obviously a much more recent case. And in that case, the court said that the protection of human rights had achieved much greater prominence, and therefore acts that might have formerly constituted inhuman and degrading acts now might be classifiable as torture, which obviously is a kind of paradigm shift from the Ireland and the UK case. I know Steve's going to discuss the MIV case in more detail. However, one important point to flag in the context of this assessment of all the facts and whether the threshold of Article 3 is met is taking into account the individual's particular vulnerability by reason of their disability. And that's a point that the Judge Karen Stein emphasised in that case. So moving on to the next slide, you'll see that the obligations under Article 3 very much mirror the obligations under Article 2, and therefore I don't propose to go through the slide in a huge amount of detail, save to flag the protective obligation, which is generally owed to those in custody, but of course a lot of arrangements in social care can constitute deprivation of liberty, applying the Cheshire West case, and therefore there's arguably a protective obligation under Article 3 that needs to be taken into consideration. The other point to flag is the procedural obligation, insofar as whether it's reason to believe that there has been treatment contrary to Article 3, then it falls upon the relevant public authority to carry out an effective investigation into the possible violations. So that's been seen most recently in the John Warboys case, which is in relation to an investigation by the police. But it's a good place to start when you're looking at the procedural obligation under Article 3. So just moving on to the next slide and touching upon the negative obligation. So the negative obligation is the obligation not to inflict treatment that breaches Article 3. So the most obvious example in the social care setting are cases of abuse. So they very much depend upon the facts of the particular case. But it is likely that at least a threshold for inhuman or degrading treatment would be met. So thinking about the negative obligation slightly more broadly, the case of Limboella, which concerned asylum seekers, reminded us that there can be a breach of Article 3 in cases where there's a denial of the most basic needs. This obviously came into play in the context of the Care Act easements, and hopefully you've seen the various guidance that Chambers has provided on that point. However, the negative obligation probably does not encompass a failure to provide positive welfare support. And I provided the case law on that point just there. Moving on to the next slide. The key cases that you might want to consider when analysing a potential Article 3 argument is the case of Bernard and Enfield. In that case, the court accepted that the claimant had been forced to live in conditions that were described as degrading. However, on the facts of that case, they considered the minimum threshold of severity had not been crossed. And the particular reason for that conclusion was because there was no intention to humiliate or debase her. Kind of broadening the scope to look at sort of supported living or community-based care, it's worthwhile considering the case of ZH and the Commissioner of the Police of Metropolis. In that case, a young boy who was severely autistic and epileptic and had learning difficulties, disabilities, he was taken to a swimming pool. And unfortunately, the visit went slightly AWR, and the swimming pool called the police. The police ended up forcibly removing him from the poolside, handcuffing him, putting him in leg restraints, and placed him in the cage back of the police van for about 40 minutes. And as a result of that treatment, he suffered from psychological trauma and exacerbation of his epileptic seizures. So that case was appealed to the Court of Appeal, and Lord Dyson made two principal observations. The first one I'm not going to address in any detail, but concerns the defence under Section 5 of the Mental Capacity Act in relation to essentially defence to liability. But he emphasised the striking features of that defence is that it's pervaded by concepts of reasonableness, practicability and appropriateness. And on the facts of that case, the police just hadn't acted reasonably, practically and appropriately, given the presentation of the young man. With regards to Article 3, Lord Dyson upheld the findings of the first instance judge, taking into account that he was a very vulnerable young man. He had autism, he was epileptic. The episode lasted 40 minutes. He didn't understand what was going on. He was forcibly restrained for 40 minutes. He lost control of his bowels, and he wasn't in a position to be comforted by his carer. And following that experience, he suffered PTSD and an exacerbation of his epileptic seizures. So on the facts, Lord Dyson accepted that the judge was right to conclude, or didn't call into question his conclusion that indeed that constituted a breach of Article 3. And then finally, the case of the Blue Room, which is the case of on the application of C at the bottom there. In that case, the claimant alleged breaches of Articles 3, 5 and 8 on the basis of him being secluded in what was called the Blue Room. Unfortunately, the matter wasn't actually determined in the end by Miss Justice Ryder, or that part was settled. However, on the facts of the case, it seems likely that it would have constituted a breach of Article 3, bearing in mind the young man had severe autism, severe learning disabilities, sensory impairment, and there had been a significant failure to comply with the Code of Practice under the Mental Health Act. So moving on to the next slide. So Nicola dealt with in some detail what the general positive obligation requires. So essentially it's putting in place systems to ensure that individuals within the jurisdiction would not be subjected to treatment contrary to Article 3. So it most obviously requires an effective regulatory framework. In terms of when a breach of this obligation, I should say an actionable breach of this obligation might occur in a social care setting, really you need to look at a systemic failure which leads to harm to an individual. So looking at recent circumstances, if, for example, there's a systematic decision that certain care home residents or others in a supported living arrangement won't be taken to hospital, and as a result of that decision, they then suffer treatment contrary to Article 3 by virtue of immense suffering, then arguably there would be a claim for breach of the general positive obligation. So moving on to the operational obligation, again, Nicholas laid this out in some detail, but it is worth flagging that it can also occur in the context of treatment contrary to Article 3. In the Z in the UK case, the court considered that there was no doubt as the failure of the system to protect these applicant children from serious long-term neglect and abuse. So it's important to bear in mind that once a risk, a real immediate risk, has been detected in relation to a particular individual, then there is the obligation to take reasonable measures. I've also flagged there the case of D in the UK, which concerned the withdrawal of HIV treatment from someone who was going to be deported back to St. Kitts. That is perhaps an exceptional case, but it is worth flagging because indeed, if you do have someone in a care home or supported living setting who hasn't been given the treatment they need and they suffer as a result of that, that could potentially constitute a breach of Article 3. So moving on to the protective obligation, again, it is just worth flagging that under Article 5, one of the grounds for lawfully detaining someone is in relation to the therapeutic elements of that detention. So the key case to look at really is Ruman, which is the case I referred to at the start of my part of the talk. The importance of looking at Article 5 alongside Article 3 is ensuring that indeed the individual who's being deprived of their liberty, deprivation of that liberty is linked to the therapeutic aspect of their care. With regards to the cases of Ruman and Hertzgovalfi, it is just worthwhile flagging that the court has taken into account the fact that individuals with mental disorders are generally more vulnerable than ordinary detainees. And that also, a point from Ruman, is that they might not be able to complain coherently or at all about how they are being affected by a particular treatment. So again, that's another relevant factor to take into account when assessing whether or not the Article 3 threshold has been met. And then finally, just to end with a couple of points, which is just that the European Court case law has made it clear that if there's been a deterioration in an individual's mental health or exacerbation of their naturally occurring illness, then indeed that can also constitute a breach of Article 3. So now I'm just going to hand over to Steve, who's going to address you on Article 8.
Thanks very much, Steph. I can work my own slides now, and looking forward to any questions or comments that colleagues may have. And I'm going last, but I think not least, on Article 8, because I would suggest that sometimes Article 8 can get overlooked when people are thinking about human rights, potential human rights breaches in the social care context. And there's often a very great and very significant focus on Article 5, for example, and issues around deprivation of liberty, whether a deprivation of liberty has occurred, whether it's been properly authorised. But actually Article 8 goes to the things that tend to matter to people who receive social care, in terms of the quality of the care that they get, the support that they may need to maintain relationships with their family, friends and the outside world, issues around dignity, autonomy, choice, control. Those are all aspects of rights that can be protected under Article 8. So I think it's a very good place to end up, actually, because although Article 2 and Article 3 are, of course, extremely important absolute rights, they are only engaged in more extreme cases. Whereas Article 8 gets us closer to the small places close to home that Eleanor Roosevelt wrote about in terms of the importance of human rights. So it will be well familiar to many people attending the webinar, of course, but it is important to emphasise how Article 8 is structured, that Article 8.1 provides that everyone has the right to respect for their private and family life, their home and their correspondence. And then under 8.2, there should be no interference by a public authority with the exercise of that right, except as is justified in the ways that we know, and I'll come back to justification in a moment. So that's the structure of the article. In terms of some issues that are likely to arise in the social care context. First, and perhaps most obvious question is, does Article 8 create a right to access social care at all? And the short answer to that is most likely not, but it is of course a little more complicated than that. First thing to flag is that in the European Court's decision in MacDonald in the UK, Elaine MacDonald's case that went from the Supreme Court to Strasbourg, the European Court found that the withdrawal of a service, in that case overnight care, could be treated as an interference with the Article 8.1 rights, which therefore failed to be justified under Article 8.2, and therefore had to be proportionate and in accordance with the law. And in Elaine's case, for a limited period of time, that interference wasn't in accordance with the law because there hadn't been a reassessment as was required by the domestic legislation then in force. So there was a breach of Article 8, but on a fairly narrow basis. The challenge on the basis of lack of proportionality didn't succeed. But that's an interesting approach, I think, for the Strasbourg court to take a different approach than was taken in the domestic courts. It'll be interesting to think about how far the High Court would be precluded from following MacDonald and the UK based on the Supreme Court's decision. That's an issue that would need to be considered carefully. But certainly, if a case got back up to the Supreme Court, then they would be free to follow MacDonald in the UK and treat the issue of withdrawal of care as being an Article 8 interference case, as opposed to, in the remainder of the cases, trying to establish a positive obligation to actually provide care. And that has proven very difficult indeed. Steph's mentioned Anna Frajeva, which is still the leading case in the area, but a much more recent analysis by Karen Stein as a Deputy High Court judge is in the MIV and Newham case, which was about failures to provide, or alleged failures to provide, a suitable accommodation to a disabled child and their family. And what the judge did was analyse Anna Frajeva very carefully and the other cases and come up with essentially a three-stage test as to when there would be a positive obligation to actually provide care under Article 8. So first of all, there was a failure to provide a benefit to which the claimant was entitled as a matter of public law. Well, that's an extremely hard starting point, because if you've got to establish a public law error in terms of an entitlement, essentially you're saying that there's a breach of the duty under the Care Act for an adult, or a breach of the duty under the Chronically Sick and Disabled Persons Act, or Section 20 of the Children Act for a child. Not sure in that context what more Article 8 really adds, other than potentially a right to claim damages. So that's a high first hurdle to get over. Then there has to be an element of culpability, grounds for criticising the failure by the public authority to act. And finally, there must be a serious impact on either the family life or the private life rights of the person bringing the claim, such that they've been caused substantial prejudice. So it's a high bar to get across. And in practical terms, other than Bernard, or Bernard, it's not obviously there's been a case where an Article 8 breach has been found in terms of positive obligation, and Bernard was very close to, although not quite, an Article 3 case. So if you're not in MacDonald in the UK territory and you can't argue issues around withdrawal of care, asserting a positive obligation under Article 8 is going to be very difficult indeed. Perhaps one area that could be explored further is how far the unincorporated conventions can link into Article 8 and bolster that the positive obligation here. For example, Article 19 of the UN Disability Convention, in terms of rights to independent living and community inclusion, could conceivably have some force in that analysis of whether a positive obligation arose to provide care, for example, in a person's home location, as opposed to them being sent away to an institutional setting far from home. So there's definitely still avenues to explore, but the ground isn't particularly fertile so far in terms of duties to provide services under Article 8. And the court is very resistant to the idea that Article 8 could be transformed into any kind of socio-economic right. Where I think Article 8 has much clearer application and force is around restrictions that are placed on people that may well not give rise to a deprivation of liberty, but which still limit their ability to enjoy their private life, which includes their association with other people and or their family life. And one area that's been of particular interest during the current pandemic is restrictions on visiting. Some social care providers and other institutions have put in place blanket bans on visiting during COVID-19. And it's obvious, I suggest, that any kind of restriction on visiting will be an Article 8.1 interference, and therefore it will need to be justified. And the person who's imposing that restriction, first of all have to ensure that it's in accordance with the law, and the law in the convention context is interpreted rather broadly, including relevant guidance. And in that context, it's interesting that the current guidance on NHS settings does permit visiting, and says that whether visiting is permitted is a matter for local decision making by NHS trusts and other bodies. So to have blanket bans on visiting, certainly more than at a local level, would be inconsistent with at least the NHS guidance, although not specific guidance on social care. And it's particularly relevant, I suggest, but there's no guidance at all at the moment in force on supported living and COVID-19. Hopefully that will be remedied shortly. But even if the restriction is in accordance with the law, it must still be proportionate, so necessary in a democratic society. And the key issue in any kind of proportionality assessment, I'd suggest, is going to be the final stage of the four-stage test for proportionality that the courts have laid down over and over again, which is whether it strikes a fair balance between the rights of the social care user and their family and any other wider interest, which may well, of course, include infection control, for example. So is the measure that's being used proportionate to the aim which the relevant authority is trying to achieve? And that will, I'd suggest, often need to be a case-specific decision. For example, can the family access the setting without going through communal areas? Or can they meet the person in a part of the setting where others won't be present? Those sorts of questions need to be looked at carefully rather than having blanket or straightforward bans, I would suggest. How about the procedural obligations under Article 8? I think this is another very interesting area which would merit further exploration. Article 8 on its face doesn't contain a procedural obligation, but it's well understood that there is an implied obligation, and perhaps most clearly expressed by Mr. Justice Mumby as he was in the Derbyshire police case. In essence, for people to be engaged and involved in decision-making processes to the extent that's necessary to protect their Article 8 rights. And it's really reflective of the disability rights movement principle of nothing about us without us, that decisions shouldn't be taken that impact on people's private life and family life without their appropriate involvement in that process. And that will include children, of course. There's procedural obligations specifically in relation to children in the Children's Rights Convention and the Disability Rights Convention, and disabled people, older people, anyone for whom decisions are taken that impact on those protected rights. And they probably mirror the common law requirements of procedural fairness in any event, I'd suggest. And one area that's directly linked to social care, where I'd suggest that this implied obligation is particularly relevant, is the way in which panels are used, or arguably misused, in relation to decision-making on resource allocation. The Care and Support Statutory Guidance says that local authorities can use panels as a form of moderation for their resource allocation decisions, but they shouldn't use them as ways in which resources should be determined per se. And I'd suggest that's an appropriate and accurate reflection of the legal position. Because if a case is simply taken off to panel with the family or the disabled person having little or no involvement in that panel decision and little or no opportunity to have their voice heard, I suggest that may well breach the procedural obligation in Article 8 and therefore be unlawful as a result of Section 6 of the Human Rights Act. Similar considerations arise, I'd suggest, when when resources are determined by resource allocation schemes or systems, RASs, an attempt to calculate a value of a package by reference to an assessment of need. And the Supreme Court held it in KM and Cambridgeshire some time ago that RASs shouldn't be used in that way and should only be used as a kind of ready reckoner of the value of the package. But if they are overused to determine packages of care, I'd suggest not only is that going to be unlawful under the statutory scheme for social care, but also may well breach Article 8. The last point I wanted to raise was in relation to private providers of social care, because but the vast majority of adult social care now, and indeed children's social care, is going to be provided by non-state bodies, companies and or charities. And the general rule is that no human rights claims can be brought against private bodies, subject to an exception for what are described as hybrid public authorities, which would be private bodies which are exercising functions of a public nature, and which can, and in relation to those functions, human rights claims can then be brought against them. And there are a number of cases on the question of whether providers of social care, residential care or other care were public authorities. And the House of Lords in Leaded Cheshire said that they were not. That was then reversed by Parliament, and most recently in the Section 73 of the Care Act provision, Parliament has made clear that registered care providers who are providing care and support to an adult or support to a carer, while providing personal care in the place where the adult is living or providing residential accommodation together with nursing or personal care, are treated as public authorities for the purposes of the Human Rights Act, so long as the care and support is arranged or funded under the Care Act. And that's the analysis that applies for England. Of course, there's equivalent provisions for the other UK nations in relation to their legislation. Now, that's straightforward now and has been accepted. And there's been a number of cases I've been involved in where claims have actually been issued or threatened against private providers citing Section 73 of the Care Act. And there's been no dispute that they are public authorities for Human Rights Act purposes because of Section 73. But a number of interesting issues arise. First of all, what about those whose care is funded by adult continuing healthcare, by NHS bodies, clinical commissioning groups? They're not expressly caught by Section 73. But in my view, it would be a breach of Article 14 of the European Convention, i.e. the non-discrimination provision, if they weren't also to be treated as public authorities against which HRA claims could be brought. Because otherwise you could have a situation where two disabled people with similar levels of need were in the same home. One of them was under the threshold for continuing healthcare and could bring a human rights claim because of Section 73 of the Care Act. The other was just over the threshold and was assessed as having a primary health need and couldn't bring a human rights claim. And that would be perverse and, in my view, discriminatory. Similarly, what about the position for children? Because children aren't covered by the Care Act other than in relation to transition issues into adult social care. And again, it would seem to me that there's likely to be a breach of Article 14 if a child couldn't bring a claim against a private provider of care to them on the basis that once that disabled child, for example, became an adult, they could under Section 73. The analogy perhaps isn't quite as close between children and adults as it is between adult recipients of local authority care and NHS care, but it still seems to me to be close enough to establish that it would be discriminatory unless there was a good justification for it, which is not immediately obvious. So I do think it's worth keeping in mind that the kinds of issues we've spoken about this morning are now very relevant to private care providers, not just to the commissioning bodies, who will also, of course, may well also be in the frame for any human rights claim, but the claim can also be brought against the actual provider of care in many situations now, either expressly under Section 73 or, in my view, by analogy with it. And so I think that answers one of the questions that we've been asked, in my view, that would apply to CHC, continuing healthcare funded care and nursing care. Although, of course, individual advice would need to be taken. We should have given the disclaimer at the beginning, but we're not able to give any advice today. Another question that's been asked, and perhaps colleagues would like to come back on camera for this, is an interesting question about pleading. And we won't name the people who've asked the questions, by the way, just for data protection reasons. The question is, we see many claims pleaded both or in the alternative for breach of Article 3, breach of Article 8. How do the courts approach these? Nicola or Steph, would you like to take that?
Yes, I mean, I think this is very common. I mean, Steph may well have something to add, but you see claims pleaded in the alternative, and I think that acknowledges that the threshold of Article 3 is very high. So I think the first question that the court looks at really is this a case where the Article 3 threshold is met? Is it sufficiently serious, in terms of the ill treatment that's complained of? And if not, then the court will then move on and look at Article 8. So I think that's why it's done. Claimants, as it were, covering themselves on the basis they think they've got an argument, it's Article 3, but they acknowledge it's actually quite difficult to make out an Article 3 claim. So they're wanting to have the backup of Article 8.
My only observation on that is that pleading Article 3, alleging breach of Article 3, however, at the same time, the threshold is so high that you often have to at least Article is engaged. I never quite grappling with the distinction of Article 3 being engaged and free. But you're in the space, you must be in the territory of Article 3.
Sorry to interrupt, Steve, but we're having some problems hearing you. I'm not sure there's an issue with sound. It's still reverberating. I'm not sure why.
Let's go next.
I guess my only observation really is that from a claimant's perspective, in terms of how you present your case, even if you do think that the facts don't meet the Article 3 threshold, to show that you're sort of taking the case seriously, sometimes it's better to plead both Article 3 and Article 8 in order to kind of protect your client's position, and so the court takes it, say, seriously. I think we have a few more questions coming in, don't we? So we have a question about whether claims are time barred. There is a primary limitation period under the Human Rights Act of 1 year. There's also the jurisdiction on the court to extend time. Don't even know further to add on that. Sorry, Nicola, I think you're on mute.
Yeah, sorry, I was on mute. No, I was just going to say that's a broad discretion because it's on the basis of what's just and equitable. I mean, you don't have the same criteria like you have, say, in personal injury claims, where you have all the factors set out in Section 33. That there isn't anything similar in the HRA, but there are cases where the courts have looked quite closely at those factors and taken them into account.
And just to add that very briefly, there's an interesting case of AP and Thameside, which emphasises that no particular factor is given more weight than another factor. So in that case, the claimant, the litigation friend, lacked capacity. So the argument was run that there was an irrebuttable presumption in favour of granting the extension. And the court dismissed that argument, that there's no particular factor that's given more weight.
Yeah. Is there anything else? I can see there's a question here about Maguire and Article 2, asking would the situation be different if you're dealing with a voluntary psychiatric patient at a psychiatric hospital who was subject to doles rather than detained under the Mental Health Act. I think all sorts of issues might arise there anyway about whether they could be subject to a doles, you know, if they were otherwise met, that could be detained under the Mental Health Act. So in fact, that may not be available. But the situation in relation to psychiatric patients in hospital is as set out in the Rabone decision, and there's also a European Court decision confirming that now, that the operational obligation can be owed to such patients. And the thinking is that they're very vulnerable. They're often in quite a similar situation to patients who are detained under the Mental Health Act, because if, for example, they became non-compliant, they would be detained. So those cases are different.
Nicola, I think there's a question here on victim status in relation to whether a family member could bring a claim for breach of the investigative obligation under Article 2.
Oh, yes. Yes, families can do that. I mean, there's case law showing that families can claim to be indirect victims to pursue something, a breach of an investigative obligation. And there are various cases where that's been accepted. And indeed, that was acknowledged in domestic courts in the case of Savage. And in fact, that was one of the arguments that was being run in Rabone, namely that you could, as family members, claim to be a victim of an investigative breach, but you couldn't claim to be a victim of a substantive breach. And obviously that was dismissed as well by the Supreme Court in Rabone. It's certainly one of the factors. You'll remember at the end when I was talking about victim status, I said there are these sort of categories of particular case where the European Court has said that victims can bring claims, which aren't Article 2 claims. It might be an Article 3 claim or an Article 5 claim or an Article 6 claim, on behalf of a deceased relative. And one of the factors that the European Court's focused on in those cases, if there's some kind of argument about procedural breach, that might be a factor that would persuade the court to recognise somebody as a victim on the basis there was a real interest in this issue being looked into properly from a procedural point of view. Anything else? I think we're reaching our time actually now, aren't we? We're just past 12 o'clock. So I think we're going to have to call this to an end now. Thank you very much, everyone, for joining us. Thank you to Steve and thank you to Steph for participating, and we wish everyone a very good day. Thank you. Bye.